Let me welcome you to the Transitional Justice Study Group. This will be our final session. Zachary's really amazingly equipped to lead this session today. He's a practitioner of transitional justice. He's a scholar of transitional justice. He is a lawyer. He's a political scientist. He has written a chapter almost every year recently on the Gacaca, kind of bringing people up to date on what's going on in that process. He's published a couple of books that he's edited. One of them, After Genocide: Transitional Justice, Post-Conflict Reconstruction and Reconciliation in Rwanda and Beyond. And he was just there for the 20th anniversary celebrations there. He has a number of projects there, including starting a public library there, I believe. So when I look at kind of what he's done in transitional justice, I think we have the unique perspective of someone who studies it and does it both. And so welcome, and we're very happy to have you.
Thanks very much, Charlie. Thanks. It's great to be here. Thank you very much. As Charlie mentioned, we're going to talk today about Gacaca. Just want to start by thanking the Kennedy School for hosting this, for the Carr-Ryan Center. I want to thank Charlie, Federica, and Chris. I'll start today by talking a little bit about what's Rwanda like today. And I want to do this because I feel like Rwanda, when people think about Rwanda, when people talk about Rwanda, we mostly focus on the genocide. And a lot has happened in Rwanda since, including Gacaca. But I want to share with you some of the really incredible positive developments since '94. Also, just to help contextualize Gacaca, we can't just launch into discussing Gacaca itself. I think we need to look back at what the causes were, as this is part of the impetus for Gacaca later on. And then I want to contextualize Gacaca within other transitional justice mechanisms. There are 3 others, which we'll talk about. And then I want to draw some lessons to talk a little bit about the legacies that Gacaca and the other transitional justice mechanisms leave us with. Federica had invited me to speak for about 45 minutes, so I'll keep it to that. So today, Rwanda is really just bustling. It's incredible. This is Rwanda's first skyscraper. The picture you see here is called Kigali City Tower. It's amazing to think there's now a skyscraper there in less than 20 years since the genocide, or exactly now, 20 years. The annual GDP growth in recent years is 8%, which is really incredible for the context that we're talking about. Rwanda is now first in all of Africa in 48 states, tied with Mali for progressing towards the UN Millennium Development Goals. Corruption and infant mortality have plummeted in the past several years, while life expectancy has really risen by a full decade in just 20 years. Really, really amazing. One of the unbelievable statistics, I think one of the most amazing statistics, is about women in Rwanda. So women now hold 64% of the parliamentary seats. This is now the highest in the world. Any country in the world with an elected legislature, Rwanda leads them. And I thought I would go ahead and recommend some further reading if you'd like to learn more about the role of women in Rwandan society, politics, and business. Kennedy School professor Ambassador Swanee Hunt has a really fabulous article out in the recent edition of Foreign Affairs called The Rise of Rwanda's Women. And I really recommend that piece to you. So let's talk a little bit about the causes of the genocide. I'll divide them into 4 categories, and I really just want to share this so that when we finally get to the conversation about Gacaca, we know the context in which this was developed, and again, part of the impetus for doing so. So there were demographic, political, legal, and social, cultural causes of the genocide. There were many, and we'll just briefly review them. So the demographic causes include severe poverty at the time, high population density. In fact, it was the highest population density in the world at the time, and then severe internal displacement.
So that's more than El Salvador or Haiti?
At the time, yes. The political causes were numerous. I'll just quickly mention just a few of these. We had for a very long time expulsion of Tutsi, pushing into other parts of the Great Lakes region. A highly centralized government, which was important to what would be the sort of control and command aspect of the genocide. Massive importation of arms, including 3 million machetes in the lead up to, just in the few years right before the genocide. And then the government, of course, was distributing these weapons to the population immediately before the genocide then unfolded or sort of exploded. And then the final one I would mention is really the international community's apathy, which of course we see this in numerous places throughout the world. Some of the legal causes include a rise in not only crime, but really, much more importantly, criminal organizations. And this is important because, again, in order to affect such an efficient genocide, you needed command and control structures. And this rise in criminal organizations contributed to that. More relevant to the Gacaca discussion we'll have later is the fact that there really was a very poorly trained judiciary at the time. Right after the genocide, there were only about a dozen lawyers remaining in the entire country. And when you sort of compare that or put that side by side with the fact that there were then going to be about 1 million perpetrators, you can see just how woefully under-resourced the country was. You also had, sort of legal institutional issues with lack of protection for various human minority rights issues. Some of those social and cultural issues that contributed to the genocide, including, when the various colonial powers came in, they introduced these, racial theories, like the Hamitic myth, and others that really exacerbated ethnic tensions between the Hutu and the Tutsi. This then led to discrimination. And crucially, there's always been sort of a popular culture of obedience towards those who were in power. And this, of course, is also critical to the genocide, too, because once the sort of sign was given to kill, a lot of people, unfortunately, followed those orders. But perhaps the most important contributor to the genocide was a culture of impunity or immunity that had existed in Rwanda for decades. One of the sort of seldom discussed factors leading to the genocide is that, in fact, there had been many atrocities, in fact, genocides, in Rwanda before the massive genocide that occurs in 1994. These date back 50 years to the 50s, to the late 50s, 1959, 63. Various politicians and scholars have characterized at least the first two as genocide, and then there are other atrocities that are committed, massive atrocities that are committed in the 60s, 70s, and earlier in the 90s. There has not been a legal determination to date that these qualify as genocide, but it's entirely clear that there were massive atrocities in the lead up to in the decades leading up to 94. And so, what was the response officially? One was that just the government declined to do anything about these issues. And equally importantly, not only was there sort of a passive acknowledgement and sort of permission, but actually there was legislation that was enacted to shield these individuals. One of my colleagues, Martin Goga, calls these legislations of impunity that start even in the 60s. So again, 40 plus years ago, and they provide amnesty to perpetrators. And so basically what we're seeing is that Hutu extremists then were practicing and refining their skills, their organization of the genocide, and they learned that they could do this with impunity. And so this crucially contributes to the lead up to 94. So then during the genocide, there are questions start arising as to whether we're going to finally now bring genocide perpetrators to justice, and if so, all the sort of attendant questions of the logistics. How are we going to do this? When? Whom among them? Given again that there are probably about 1 million killers, and where are we going to do this? And with whose resources? Who's involved? And there are massive sort of coordination questions involved. And so this leads to the 4 main transitional justice institutions that are implemented. 2 of them are outside of Rwanda, 2 are inside Rwanda. And again, we'll focus on Gacaca, but I want to lay out what the other 3 are because they're relevant to the design and also the jurisdiction of Gacaca. So the first is what's probably the most famous, which is the UN Tribunal, the International Criminal Tribunal for Rwanda, which I'll refer to as the ICTR. And a couple things to say about this. It wasn't just that these external from Rwanda institutions would prosecute, but it's also that they would transfer some of the cases. So I'll give you the stats in a few minutes about which of the cases have been dealt with through the ICTR and which have been transferred to other jurisdictions. This also occurs with third-party countries on which genocidaires have sought refuge. Some of them have been prosecuted, whereas others have been extradited or deported to the ICTR, Rwanda, or elsewhere. The two mechanisms within Rwanda have been the ordinary domestic courts and then the subject of today's talk, Gacaca. So let me talk a little bit about, in a little bit more detail, those three other transitional justice mechanisms before we then get to Gacaca. So the ICTR is created in late '94. This is really incredible because the genocide ends around July, and by November there's now a full UN War Crimes Tribunal, the second one ever to be created. A few months later, the decision is made by the Security Council to locate the seat of it in Arusha, which is in Tanzania, the adjacent country to the east. So here I'd like to provide, what's the sort of work to date, and this is based on the most recent report. So all trial level work has now been completed on the 93 cases that were pursued by the court. And so this includes delivering judgments at the first instance trial level phase for 75 of those defendants, and then 46 at the appellate level. Now, 10 of these cases have been referred to national jurisdictions. I had mentioned earlier that this was one of the options, that the ICTR didn't just prosecute all the cases, it also transferred some of the cases. So 2 have been referred to France and 8 have been referred to Rwanda, although the majority of them are still fugitives. There's now also been the creation of a residual mechanism. So even after the ICTR closes, there's going to be an ongoing tribunal that will function. Basically just assumes all the responsibilities and tasks and powers of the ICTR, and that's going to be dealing with at least 3 more fugitives. And then you can see that 2 of the 93 were withdrawn, 3 of the 93 died, and the projection is that at least at the ICTR level, the work will be wrapped up by August of next year. Although, the residual mechanism will continue to operate, and it's unknown how long that might last. So if the August 2015 date holds, it will have been almost 21 years that the ICTR will have operated. For the third-party countries, these prosecutions have been pursued under one of 2 mechanisms. One is the controversial sort of assumption of universal jurisdiction. This is the jurisdiction through which it's claimed that there are various crimes historically or in the world that are so egregious that offend humanity so much that they should be prosecuted anywhere by anyone. And this is incredibly controversial, for those who think that the jurisdiction of a legal body should be limited to those which it actually has written into its laws. The second mechanism under which these prosecutions have been pursued is through actually introducing legal authority domestically that empowers these courts through the legislature introducing the laws, and then the courts pursuing them. At least 10 countries have held or are considering holding. Sorry, go ahead.
So I want to understand kind of what that number 2 meant. So did that mean that Great Britain could pass a domestic law saying our courts are authorized to try crimes against humanity, not because of your universal jurisdiction, but because of this law?
Right.
Is that
right? Right. So it's not just the courts arrogating to themselves the power to do this. It's actually the more traditional formal process of the legislature granting the power, the jurisdiction, the subject matter jurisdiction.
And so, would those laws have been, sorry, I just think that's a very interesting point. Would they have been generally specific to Rwanda, or would they have been more broad?
They would have been more broad. They would just that, that our courts have the authority to pursue genocide not on our soil. So I'm actually unaware of any situation where it's been granted specifically to Rwanda. In fact, I think the impetus all along was that we should expand the authority through these local laws to deal with genocide cases more generally, including because of the fact that other atrocities have been committed around the same time, like in the Balkans. And there's the very possibility that perpetrators from those atrocities might also seek refuge on European soil, other European soil. So there are 10 countries that are considering or already have been processing these cases. I wanted to highlight France in particular. Perhaps a disproportionate amount or number of genocidaires have fled to France. Various reasons why that might be the case, but the point is it's taken almost 20 years for the first prosecution to come forth, and some say that this is France deliberately sort of dragging its heels. One sort of allegation about this is that France may not want to sort of pursue these cases because they might lead to information coming, sort of arising that would implicate France in the genocide. There are various allegations. One of my colleagues wrote a book called Silent Accomplice, which is a really fascinating book about France's role in the genocide. And the allegation is that France armed and helped train the Interahamwe, the mobile killing squads, in part because France would like to have kept its sphere of influence in that part of the world. I thought I would point out the United States experience, since we're in the United States, we're American body right here, in two of these respects. So Elizafan Ntakirutimana hid out in Laredo, Texas with his anesthesiologist's son. He's then caught there and then becomes the first person ever in the United States history to be handed over to an international tribunal. More recently in New Hampshire, Beatrice Munyenyenzi was caught. Her husband and mother-in-law have already been prosecuted. They've been accused of participating in killings in Butare, which is the second largest city in Rwanda. And she hadn't been implicated until more recently when she was in New Hampshire. And so she was prosecuted on immigration issues, not on genocide charges. And the charge was that she lied on her immigration application to get into the United States. And that is an offense that can be penalized with about 10 years of imprisonment. And so she's convicted of that. She will serve time and then will likely be deported to Rwanda afterwards. She's claimed that her deportation will effectively be a death sentence. But given that Rwanda has abolished the death penalty, that remains to be seen. And in any case, it very well certainly would be the case that she would then be prosecuted for genocide charges, and whatever punishment, the maximum of which would be imprisonment, would follow, would come after that. Yes.
What did the first fellow do?
Elizafan Ntakirutimana. He was a Seventh-day Adventist priest who lured his flock to the church and then helped slaughter them.
Oh, that church.
Beatrice Munyenyenzi was the wife of a prominent person in Butare. So this brings us to the third transitional justice mechanism. I think it's important to note that the ICTR, the tribunal's preamble itself, the statute itself, acknowledges that there's going to be a need for transitional justice in Rwanda, that there's a necessity for the domestic courts to address the large number of suspects. It was always contemplated that the ICTR was only going to deal with a tiny fraction of the suspected genocidaires, albeit perhaps the most egregious among them. So the history behind the ordinary courts bringing these charges are that in 1975 it accedes to the Genocide Convention, but of course this is now still under the sort of Hutu power regime. And so it isn't until 1996, 2 years after the genocide, that domestic law is enacted, and this goes to Charlie's point. This is the kind of law that would then be enacted in Europe and other places that you're acting that would codify the various subject matter jurisdiction that would enable you to prosecute under those codes, so that Rwanda itself also wouldn't have to just claim some sort of dubious jurisdiction that it actually had codified law behind it. And then you can see shortly thereafter, just a few months later, initiates its first prosecutions. And that's around the same time also, by the way, that the ICTR pursues its first case.
It's fascinating to me that in a country where 4 or 5 incidents that are characterized by some people as genocide had already taken place,
Mm-hmm.
and it acceded to the treaty, so it
Yeah.
kind of speaks to the arrogance of, we'll sign this, but it will never be held accountable.
Well, and I think that leads to a larger problem in international law more generally, that a lot of countries, I think, sign on to treaties that they have no intention whatsoever of actually formalizing or following. I think we've seen that with the Rome Statute that creates the International Criminal Court. I think we've seen that with lots of treaties throughout
Pinochet
history.
in Chile, but
Yeah.
Convention Against Torture.
Yes, absolutely. So now we come to Gacaca, and this will be the focus of today's discussion. I thought I would just sort of show you a little bit about what a Gacaca proceeding looks like. So as you can see, it's outside. Gacaca literally means in Kinyarwanda on the grass or the lawn. And you can see that there's the judges sit in front, and then you might have the defendant or a witness come and speak, a prosecution or defense witness come and speak in front of the group. And then the individuals that you see sitting on the ground are members of the community who have come to participate and to watch. So as I mentioned, Gacaca literally means on the grass or the lawn. Kinyarwanda is the indigenous language in Rwanda, although Rwandans also speak French and English. English is now the official language. And so the impetus for even having Gacaca in the first place is that there was a massive backlog of genocide cases leading up to the late 90s, early 2000s. There was basically a realization that even the ordinary courts within Rwanda were never going to be able to prosecute the hundreds and hundreds of thousands of cases that were languishing. And there were 120,000 individuals already languishing in prison. And this is late 99, so some of these people would have been captured in 94 and would have been in pretrial detention for even up to 5 years, just awaiting trial. The idea is that Gacaca would not only pursue the sort of legal accountability, but also promote social cohesion, reconciliation. It originated from a traditional system of communal sort of conflict resolution, but that was always to deal with minor issues of property and marriage and inheritance, other such. It was never dealing with sort of more serious crimes. And so when Gacaca is kind of revised, it's amended specifically to address genocide charges. And even then, though, it was highly controversial within Rwanda. In fact, many politicians and jurists opposed Gacaca. They thought that it would be insufficient to address the magnitude of the genocide cases. They're imagining Gacaca as it was, that it had always addressed sort of lower level crimes. And so the concern was that it would be offensive to the idea of trying to bring some sort of justice and reconciliation to the genocide that had occurred. So the timeline is as follows. In 2001, the government of Rwanda enacts legislation. This is the first of a series of legislations that you can see later on are amended even through 2008. So while Gacaca is operating, various legislations are passed that modify Gacaca. And so
going back just a second,
Mm-hmm.
and at the bottom of the last slide,
Mm-hmm.
you said controversial in 97, 98.
Mm-hmm.
So were they actually engaging in this then, or
they
they
were
just
debating
talk about it?
They were debating it,
I
yes,
see.
at the highest levels of government.
Right.
They were convening conferences, including with participation from international actors, from folks outside. And then it takes a few years to actually decide to, in principle, to pursue it. And then in 2001, it's finally designed and passed through the legislature. And so initially there are 4 categories, and this is important because we'll talk a little bit about how this changes in the various sentencing that's specific to each of them. And so the Category 1 cases are the most egregious. They're the inciters, the planners, the masterminds. And then you've got on down into Category 4, which is purely property crimes. These are people who are taking advantage of the chaos of the situation to just loot and destroy. Sorry, did you have another question, Charlie? Okay, sorry. And so the division, the decision is made to divide categories 1 from categories 2 through 4. Category 1 will be addressed through the ordinary courts, the national courts. Gacaca will oversee categories 2 through 4. That's then changed later when a few of the categories 2 and 3 are combined. And then also part of Category 1 is now fielded out from the national courts to Gacaca just to help continue to expedite the cases and to streamline the process. Also in 01, so we saw in 01 in January, the legislation has passed. Later in October, we have the election of approximately 260,000 judges. 260,000 judges, it's 6%. Approximately 6% of the entire population becomes judges of Gacaca, which is a really phenomenal amount. And this, of course, is intentional. The idea being that we want popular participation in the process. There are also 11,000 cells, 11,000 community courts that are actually established in which the 260,000 judges staff. We then have even further recognizing that perhaps Gacaca is not going to be sufficient. We then have provisional releasing of tens of thousands of detainees over the course of a few years to alleviate the pressures in the prison, the conditions of which are pretty dire. I spent time in the prisons in 2002 and 2001, even before the releasing, and I can tell you that it was overcrowded. It was pretty awful.
And
Yeah.
does provisional mean that they could be called back
Yes.
for trial if somebody decided that?
Absolutely, yes. But the idea being that that we need to alleviate the populations in the prisons.
So it's kind of a parole in that way?
Yeah, exactly like a parole.
What did it take to make a judge, those 26,000?
So there's various-
Or you read a book or something?
There's various criteria. You, for example, could not have yourself participated in the genocide. You had to be sort of a respected person in your community. And there were trainings. You didn't have to already have been trained. And in fact, lawyers and judges were barred from becoming judges. The idea being that there was a sense that we wanted this to be a communal, popular system, and we didn't want that, affected by sort of formal justice and formal jurists. And so there's the election, and you could be disqualified even later on if it arose that you were corrupt or somehow too connected to defendants or other participants in the cases. Charlie?
Is there data, I know this might be very sensitive, but is there data about how many were Hutu and how many were Tutsi?
There is some data, and I'm gonna talk a little bit about data in a minute, although much more needs to be done. So we'll get into data in just a moment. But you're absolutely right that it's a fascinating question, and one that also affects, of course, just how fair and representative we think that the system is.
I have a question too.
Sure.
If you're disqualified as a judge, right?
Yep.
What happens to the proceedings that you already participated? Does that
So-
impact?
So there were other judges that served, and there were even deputies that could step into your position. There were people who were chosen precisely to become effectively alternates to fill in when just a situation would arise. And it wasn't just if you were disqualified because of some sort of conflict of interest. There were also if you got sick or other things happened, so you needed alternates.
Okay.
So how does Gacaca sort of work? So there are weekly meetings or about weekly meetings. There are various stages in each of these cases that come before Gacaca. That can involve recategorization. So as more information comes forth through the investigation, someone who's a Category 4 defendant may become a Category 1 defendant, or vice versa. And so we also see that there's exchange of cases between the national courts and Gacaca, which makes the sort of tracking as an academic who focuses on this very challenging and complicated. Plea bargaining is highly encouraged. So this, of course, is different than the sort of civil inquisitorial system, much more familiar to us in the United States under common law or adversarial proceedings, where plea bargaining is often used to, again, sort of promote efficiency, alleviate the kind of backlog. But also there are spiritual and religious reasons and social reasons why in Rwanda it wasn't just legal, why you would want to promote plea bargaining so that people actually take ownership of what they've done. Punishments can include imprisonment and community service. This is at the Gacaca level, and I'll talk a little bit in a minute about the durations. And then there are various appeals. So you can first appeal within the cell, which is the lowest, the smallest unit, and then you could appeal up to the sector, which is the next administrative unit and beyond. So we won't go through the whole chart. This is from my colleague Phil Clark in his book about Gacaca, which I think is the best book on Gacaca, called The Gacaca Courts, Post-Genocide Justice and Reconciliation in Rwanda. Fabulous, I think, subtitle, Justice Without Lawyers. As a lawyer, I try not to be too offended by that. But I thought I would show you just very briefly what the sentencing was. And you can see how plea bargaining and confessions play such a critical role in Gacaca. And so you see in the second column, what guilty with no confession. So at no point do you confess what you've done. You then see guilty with confession during the trial, which is one step less, sort of one step reduced in your prison time or whatever your sentence is. And then guilty with confession before trial is, of course, the best, because then you really avoid a lot of the administrative burden, so that's highly encouraged. You then have minors who have even more reduced sentences, minors at the time that the offenses were committed. And then down here I just have a little note that if you were younger than 14 at the time, then you're just not prosecuted at all, but you might be sent to what were called solidarity camps, which sort of promoted knowledge and sensitization about what had happened. And so you can see that the worst, the sort of most severe sentence you could get was judgment category number 1, and you didn't confess at any point to what you had done, and you were convicted, you would get life imprisonment. You also see that at various points, community service might be part of your sentence. And community service is a crucial aspect of Gacaca. You know, in a post-conflict country that had much of its infrastructure, not only people, but infrastructure decimated, there needed to be a lot of rebuilding. And so community service involved rebuilding roads, homes, and other aspects of society.
Is your left column there is the same as the previous one, where you had the severity of the crime?
Yeah. So
there were
it's
4, right?
right, but then as I tried to highlight, in part of the modifications to the organic law that is passed by Parliament, the 4 categories are collapsed into 3 categories for various sort of efficiency reasons.
Collapse 2 into them, or you just read it? Did they redo entirely, or just collapse 2 of them?
They collapsed mostly 2 and 3,
Yeah.
but it's a little more complicated than that, because part of category 1 then gets addressed by Gacaca. And so this chart is based on the post recategorization. Yep. So what happens? So those are the sentences, but here are now the stats. It operates for exactly 10 years. So from June 18 of 2002 to just recently, June 18 of 2012. And the administrative body that oversees it reports the following statistics. So it tried about 2 million cases, and but within that it tries about 1 million people. And the reason why those stats are different is because sometimes groups of people would kill one person, and sometimes one person would kill groups of people. And so you have you have different numbers for the cases, but also the sort of individuals involved. You see that there's an 86% conviction rate, but crucially, 14% are acquitted, and this helps, I think, partly respond to some of the criticisms at the outset of Gacaca that this was just going to be mob justice, and so it's very important to see that that we are seeing acquittals, and then on appeal we're seeing reversals. at 26%, more than a quarter of the cases that go to appeal are reversed. So it can't just be that's sort of mob justice and retribution. I thought I would just briefly compare ICTR and Gacaca. In some ways, this is a very unfair comparison. They're apples and oranges. They're not. It was never supposed to be that they would be substitutes for each other or in any way comparable. But I thought I would just kind of show them side by side for a moment. So we see the ICTR has been going for 19 years, as I mentioned. If it goes to August of 2015, if it operates until then, it'll have been 21 years, or about 21 years. Gacaca was exactly 10. We see the difference in the number of cases. The difference in the cost is really significant also. You can see over $1 billion as opposed to 50 million. There are lots of criticisms of the ICTR for that amount of money. We see that ICTR is located outside, whereas Gacaca is in. The temporal jurisdiction is also a crucial difference. And this was one of the criticisms of the ICTR when it was created. In fact, Rwanda held, by a sort of odd coincidence of history, Rwanda held one of the non-permanent rotating seats on the Security Council at the time. And both for the first half of 1994, when the genocide was occurring, that contributed to confusion and deliberate misinformation that was disseminated amongst the members of the Security Council. And then after the genocide, in the latter half of 94, when the sort of post-genocidal regime then takes its seat in the Security Council, that contributes to Rwanda playing a direct role in the creation of the tribunal. One of the reasons why Rwanda ultimately votes against the ICTR through the UN Security Council, it was the only country to vote against the creation of the tribunal, and in fact it requested the tribunal's creation originally, but because of the actual design of it, they ultimately voted against it. One of the reasons was precisely because of the temporal jurisdiction. So the argument, the temporal jurisdiction of the ICTR is the calendar year of 94. The argument from the Rwandan perspective as to why that doesn't make any sense is because if indeed, and we all, I think now agree that it was a planned genocide, there were years of planning, as I mentioned, the importation of arms, the creation of various criminal organizations. And so it makes sense to, date back to when the start of these hostilities and planning would have occurred. And that would have at least happened, or sort of the latest it probably would have happened would have been October 1st, 1990, which was the start of the Rwandan Civil War, which I'll leave for another discussion. But crucially, the temporal jurisdiction is very, very different. The participation, of course, is also very different as well. So let's talk a little bit about the criticisms. I've already mentioned a few of them. There are basically three types, and there are others as well, but these are kind of the main ones. One is sort of due process criticisms. There's no right to attorneys. The question about you had asked about who are these judges, that they are insufficiently trained, and I had mentioned that indeed all of them were barred from even participating in Gacaca. There's concern about bias that in the years after, including in late '94, there are allegations that the Tutsi group that had fought in from Uganda and stopped the genocide, the Rwandan Patriotic Front, which is the group that's now in political power in Rwanda, there were allegations that they committed their own atrocities as well, and yet they haven't been, these atrocities, these crimes, these allegations have not been addressed through Gacaca, and so the allegation is that Gacaca is therefore biased. In terms of the actual operational criticisms, there have been concerns about intimidating witnesses. Some witnesses, have disappeared or been killed, and so there are concerns about reprisals. And then, if the sort of one of the primary purposes of Gacaca was to promote social cohesion, one of the criticisms about the operation of Gacaca is that it's actually produced the exact opposite, that it's actually exacerbated tensions that remain in the society. Now, how do we respond, or how do some respond to those particular criticisms? One is that, look, we understand that this is imperfect. but it was necessary to alleviate the backlog of cases. And given Rwanda's financial situation and infrastructure, it was a practical, feasible solution. And that also, it has various virtues that the ICTR lacks. One is that Rwandans actually get to participate. One of the huge criticisms of the ICTR is that the UN, given that the UN had been the body that abandoned Rwanda, where does the UN get the right to assert primary jurisdiction, which means that it could prosecute any cases it wanted, and leave Rwanda not to be able to address even the most egregious offenders and planners of the genocide. And so here comes Gacaca, which is fully participatory of the local community, not only the government, but the people. And then also, related to that is that it's actually owned and staffed by the population, by the Rwandan population. I thought I'd offer some stats. For those in the room who are interested in pursuing research on the topic, there's very little, now that Gacaca is finished or recently finished in 2012, this is the time to, I think, conduct real quantitative research on how it operated, who staffed it, to get back to Charlie's question, and questions of corruption, of bias, etc. And so one of the first empirical, this actually is the first empirical study, was just published this year, although the research was conducted a few years ago. This was published in the most recent, or one of the recent issues of the International Journal of Transitional Justice. Really excellent article that I really recommend to you, just like Ambassador Hunt's article. So the sample size was 500. What they were looking for was empirical feedback. They wanted they were conducting survey research on the population to get their impressions of Gacaca. And obviously impressions don't necessarily mean the actual effects, but it still provides some insights. And so just to sort of give away the results before I tell you what the stats were, the conclusion was that most answers to sort of general questions about Gacaca were positive. So the sort of Gacaca as an institution was a good thing. But we then see more negative responses to when you start getting into the specifics of how it actually operated. And I'll offer a reason as to why there may be conflicting views held. So I won't sort of go into all of this, but just to give a bit of an idea as to the stats involved with the responses. We have a strong majority, overwhelming majority in those high 70s, high 90 percentages of people saying, generally speaking, Gacaca worked well. That, and also, we see that, judges were impartial, the elections went well, it contributes to improving society. We still have majorities, but sort of smaller, concerning, competence qualifications and corruption. So I'm concerned that Gacaca judges were not well qualified, of course, means that 69% thought that they were. 59%. So then we get to sort of other global questions on the outcomes, that it actually helped in various ways, that it provided a true account of what occurred, and these are all over 90% sort of satisfaction. Now when you get into the kind of nitty-gritty of how it worked, we now start to see some troubling responses. And so one of the troubling responses is that there were acts of retaliation, 62% saying that, both interestingly on the prosecution and defense side, and that there were a lot of people lying at Gacaca, or at least this is the impression.
Wow, that's a very interesting statistic.
It is, yeah. And not necessarily, of course, an indictment of the system, but more an indictment of the process, or sort of how people were participating in it. And so these are the conclusions, at least, that the writers draw, which is that there is a disconnect, but one that can be explained, and that's that you basically have popular support for the idea of Gacaca. And in fact, some of the positive kind of responses might have been sort of parroting back the kind of, what the government had sort of described as the impetus for and the hoped outcomes of Gacaca, but then you actually see dissatisfaction with how it actually operates, particularly about how security and credibility function. So let me just run through what do you want to do, Charlie? Because we've been taking questions throughout. Do you want me to keep?
No, I think you can keep going.
Keep going?
And I think it's great that we've been answering questions. So.
Okay, good. Okay, so let me talk a little bit about some of the various legacies from all of these institutions, including Gacaca. And I'll talk about them in terms of the legal legacies that are left, the institutional ones, and the conceptual ones. So one concerns the death penalty. And so Rwanda had the death penalty until it's abolished in 2007. And Kagame himself said that part of the reason why this had to be abolished is because the government couldn't have become a mass executioner in order to correct mass murder. There would have been thousands of killings if the death penalty had remained on the books. But not only that, a more cynical reason, although of course it's not mutually exclusive, is that abolishing the death penalty paved the way for various cases that the Rwandan government wanted itself to investigate and prosecute to be transferred back to Rwanda. So various European countries, as well as the ICTR, are prohibited within their own rules from transferring cases or extraditing or deporting to any jurisdiction that has the death penalty. And so if Rwanda wanted various cases to ultimately come back to its own jurisdiction, it had to abolish the death. And some believe that one of the legacies is also that this has now contributed to the global abolition of the death penalty, being that if there was ever a country that sort of had faced crimes such a massive amount in the modern day that might be deserving of capital punishment, it would be Rwanda. And if Rwanda abolishes the death penalty, maybe we should give this a second thought. Various legal legacies for third-party states, so that was Rwanda. One is, I mentioned, the sort of controversial assertion of universal jurisdiction. Various countries have asserted this type of jurisdiction, although interestingly some have now backed away from it for various political reasons. There's also been, as we were talking with Charlie, the incorporation of various subject matter jurisdiction over atrocities into domestic law. And then certainly it's the case that the Rwandan genocide, the genocide against the Tutsi in Rwanda, contributed to the more global campaign of finally establishing a permanent international criminal court through signing and ratifying the Rome Statute. Yes?
Sorry, just a question on the previous slide. On the second point of criticisms, has anything been transferred from the ICTR even after the abolition of the death penalty in Rwanda?
So, sorry, one of my first slides noted that there are 8 cases, including 6 that are fugitives.
Okay.
A few of the sort of legal legacies at the international level, really significant contributions that the ICTR has made. So we've talked a little bit about some of the criticisms of the ICTR, but some of the real benefits that the ICTR have given us are these precedents in international criminal law. The first is the first conviction of a head of government ever for genocide. That was Kambanda. We also had the first time that rape and sexual violence are codified in international criminal law. That's in the Yakayezu case. That also, by the way, the Yakayezu case was the first conviction of genocide ever. So not just, as in the Kambanda case, the first head of government, but actually just genocide. And then a really significant development also is that in the media trial is that mere speech could constitute genocide, direct and public incitement to genocide. Various institutional, those were legal legacies. Some institutional legacies now, from Rwanda, and then we'll talk about other levels too. This idea that really we need a system for addressing the overwhelming majority of cases, and so the legacy, of course, here was Gacaca. As I mentioned before, the ICTR was never intended to deal with all of these cases. My colleague Phil Clark mentions the real scale of Gacaca itself. These are just unbelievable observations. So nearly every single Rwandan adult participated.
Wow.
So nearly every single one of them, either as a defendant or as a witness or maybe as a judge. Every single person in society who's an adult participated. And so this was the most so says Clark, one of the most comprehensive, or it is the most comprehensive post-conflict transitional justice system attempted anywhere ever. And a lot of people have taken notice of this, and so now there are questions about whether this could be applied to other situations. Also, questions arise then of whose priorities and preferences matter. You have a massive atrocity. Who gets to call the shots? Who gets to decide? Is it the international community? By the way, the same one that literally abandoned Rwanda. I just spent time at the École Technique Officielle, where literally the UN peacekeepers had established a safe haven and literally abandoned the Rwandans to be slaughtered. And so the question is even though Rwanda has been the focus of a lot of criticism for Gacaca, whose sort of principles and priorities matter most in that situation. We had, of course, the establishment of the ICTR. In some ways, it's really significant because it was only the second time that the Security Council had established a subsidiary body in the case of a war crimes tribunal. It was the first time that such a body was established to deal with a purely civil internal conflict. All the other tribunals before it, Nuremberg, Tokyo, and Yugoslavia, were international conflicts. And this has now led to the proliferation of other war crimes tribunals throughout the world. I would argue that there's a lot of path dependence involved. In fact, my next book, which is on U.S. foreign policy on transitional justice, focuses on this issue of path dependency being perhaps the best explanation for why we get transitional justice bodies created in the way that they are. And there was a lot of path dependence in this case from the ICTY. I had mentioned before that the ICTR was created in 94, even the same year as the genocide. Amazing to think, except for the fact that the ICTY was created on May 25th of 1993, and they could literally just adopt the same statute with minor modifications.
So path dependence means kind of that it largely follows in the footsteps of something else.
Absolutely, yeah. Some other legacies, we were just sort of talking about this in terms of the criticisms of the ICTR. Originally, up until 2003, so for the first about decade of the existence of the ICTR and the Yugoslav Tribunal, there was a shared chief prosecutor. And the reason initially was because they just had a really desirable person. Richard Goldstein had been a justice in South Africa, so you already had an African jurist who was chief prosecutor of the ICTY, and could be, whose mandate could be expanded for the ICTR without having to get into, finding another person who would be acceptable to all. But as I mentioned, this position, it wasn't just Goldstein. The position, problematically didn't focus sufficiently on Arusha, on the ICTR. And so all the other ICTs, all the other international criminal tribunals have had their own chief prosecutors. That's going to be a legacy. We've talked about how slow it's been, the ICTR rather, and how expensive it's been. And so some of the legacies are that we need to design transitional justice mechanisms to be faster and more efficient. And indeed, the ICC in some ways does that in both cases by having, and one of the primary reasons to have the ICC in the first place, so that you have a functioning, operating institution that's ready to go instead of having these startup sort of delays. And that reduces, various costs. The capacity of the ICTR has been problematic. You had mentioned, the unbelievable stat of 90 cases versus $1 billion. And so we're seeing that, a need for more simultaneous and sequential transitional justice institutions, and that they then should affect local capacity. Participation at the international level has been terribly problematic. And so hybrid tribunals that have been created subsequent to the ICTR, particularly for Sierra Leone and in Cambodia, the Extraordinary Chambers in the Courts of Cambodia, the ECCC, have incorporated laws and personnel from both the international level as well as locally. Location has been a problem of the ICTR, but in the ICC, while based in The Hague, is still also problematic. It's far from the site of most the atrocities, but a lot of the subsequent ad hoc tribunals, not the permanent one, but the ad hoc ones, have been created on the site of the atrocities, and this includes the Iraqi Special Tribunal.
As an example of that, one of the prosecutors for the hybrid court in Cambodia came through, and he said they had bussed in 600,000 Cambodians to watch or to participate in some fashion.
And it's certainly more feasible to do that if it's on the site of the atrocity. There have been various criticisms of ex post facto legislation, and part of the reason why this is problematic is because you then don't have a deterrent effect if the laws aren't on the books that certain kinds of crimes are illegal. And the idea is that the ICC helps to mitigate that at least a little bit, but it doesn't have a legal jurisdiction. It's been focused at least today on Africa, so that leads some to think that it alone is insufficient. There have been concerns about the authority of some of these transitional justice bodies. For example, that the Security Council created the ICTR, but the Security Council, at least as currently designed, is not fully representative of the world. But switching to a treaty-based tribunal for the permanent war crimes tribunal is one sort of way of dealing with of that, because it could be much more representative. But the problem is that not all states have ratified it yet. We also have various kind of development of international law. One of the reasons to have a shared appeals chamber for the Yugoslav and Rwanda tribunal is so that when appeals do work their way up, when cases do work their way up to the appellate level, you at least could have the coordination of jurisprudence. Of course, it would be a disaster if one court said rape can't constitute genocide and another court would say that it could. And so that's been a problem with the further proliferation of ad hoc tribunals, but with the centralization of the creation of the permanent war crimes tribunal, hopefully that could be avoided. Victims have largely been excluded from transitional justice bodies, but as we talked about, Gacaca does include them, and the ICC's trust fund was designed to do that too. We're almost finished. So we now have various institutional capacities at the international level as well. We have, since '94, and as a direct result of the Genociding Institute in Rwanda, we have special advisors for both responsibility to protect and genocide prevention. Here in the United States, we've had a massive development of infrastructure to deal with atrocity issues. At the White House, we have the Presidential Directive 10, which has elevated atrocities, including genocide, to a core national security interest. We also have the creation of the Atrocities Prevention Board, although in some people's minds it's been disappointing, especially with respect to Syria. There's the creation of a particular position within the National Security Council that focuses on atrocities. Russ Feingold is now the special envoy for the Great Lakes region, so presidentially appointed staff person who is an expert on Sub-Saharan Africa from when he was in the Senate, is now focused primarily on the Great Lakes. We also have different infrastructure in other executive agencies that focus on atrocities. And then Rwanda has been called an inspiration and a driving force for at least two of our most senior folks in the government, including Samantha Power, who's Charlie's predecessor. We also have an explosion, massive explosion. This is one of the most significant developments since the genocide of civil society. Really fantastic, really helping. This is my last slide. Finally, that brings us to the conceptual developments, legacies of the genocide, including efforts to address it through Gacaca. Responsibility to protect has been, was sort of came to the fore at the 2005 UN World Summit, where it was embraced by much of the international community, although it remains very controversial. The universal jurisdiction I mentioned is also a sort of controversial assertion. We still have a lot of problem with responding to atrocities. Most of the Tutsi who were killed, interestingly, were killed in the first 3 to 6 weeks. Some estimates hold that as many as 250,000 people were killed in the first 2 weeks. And if that's the case, then we need much more rapid reaction to atrocities. And this has now led to what we're doing here today. which is the sort of growth and expansion of various academic disciplines, including transitional justice. Still have atrocities committed all over the world, even today, even as we speak. Lots of problems with arrest warrants being unenforced from the ICC. And even though, as I mentioned, the sort of expansion of various concepts and infrastructure to deal with atrocities, it remains the case that political will is still woefully unavailable. So thank you.